Day 3 of technical deliberations at the 71st Congress of IFA at Rio de Janeiro. What a scenic place this is, and we had fun yesterday night at the Sugarloaf, all of us, and I left just before the Samba dance could start, so I missed it for sure. But here, Day 3 technical discussions, again riveting ones, just like yesterday, especially the first session, IFA OECD. You had the heavy hitters, the big guns out there today. Pascal Amans again from the OECD, Mike Williams from the UK Treasury, as also he chairs the ad hoc subgroup of the MLI here. Two special guests to discuss the sessions, panel discussions today, to give their expert takes. Manuel Tron from Mexico, former president of IFA, and of course DTS partner, renowned international tax expert TP Ostwal here. Manuel, to start with you, I think we had some intense deliberations on the multilateral instrument, and what we did realize, it's not so simple.
It is not simple, and I think has a component of great uncertainty. Even the experts and the creators of the concept do not agree on how to interpret what happens with existing treaties, and from my point of view, what is most concerning is it appears to be creating a lack of legal certainty for taxpayers, and that I think it's important.
The issue is how the countries will react to this instrument, whether they will merge two documents together, whether they will keep this as a separate document, and I believe there will be constitutional challenges in a country like India if these are not, because India is one country which does not go to the parliament, it goes to only the cabinet committee of the government, and therefore when one country adopts the process through the cabinet and the other through parliament, and the documents are not complete documents, one complete set is not presented, there will be major challenges which are going to come up. So you can't have two instruments. Every country will have to prepare separate tax bilateral document with each country. And this is going to be a major issue.
Yet we heard, Manuel, that from the panelists that MLI is an instrument, it's not an obligation. That's what, absolutely, that's what they said. It's an instrument, not an obligation. And yet at the same time, you heard panelists saying that the peer review process, Pascal talked about the India-Mauritius tax treaty, very interesting. And he said that Mauritius has kept India out of the covered tax agreements, and then what happens to the principal purpose test there? And he said that the peer review process will take care of that. Manuel and Ostwalji.
Well, the thing is, in effect, it is not an obligation. It is a means to comply with the obligations assumed under BEPS. There are plenty of obligations, there are some which are considered minimum standards, and those have to be complied with one way or the other. Something that surprised me is, as an example, the United States does not seem to have signed the multilateral treaty, but the OECD clearly said today that they are complying by other ways. So through all the means, they are being compliant. I don't know exactly how, but that's what they say.
That shows how much influence USA has on the OECD.
Any doubts?
Yes, that's correct. Now the example of Mauritius-India treaty is very appropriate because this was given in the MLI document itself. It is not that something which has emerged today. Mauritius has not signed with India for the simple reason this Mauritius-India treaty was just signed 3 months or 6 months before.
Just a year back.
How do you override that all
Absolutely.
of a sudden? So Mauritius has indicated their intention to re-sign the new treaty and negotiations will be on. And therefore they says we will not go by multilateral but we will go by the bilateral.
Final word on the MLI before we move to the next topic, and that is that you have a multilateral treaty, and yet you're going to keep the window open for bilateral negotiations, Manuel.
That looks like it because at the end of the day, you have to have two parties to a bilateral treaty, even if both consent to the multilateral and with the deposit, you have to see whether the elections coincide and match and how they're going to be resolved. Most likely, it will end to bilateral negotiations in every case.
Few minutes before you said it is an instrument, and modality was explained that the domestic law of each country will have to adopt that.
Yep.
Then only it will become effective.
Yep.
And once the domestic law adopts, then it becomes a domestic rule.
Yep.
Now, however, the treaties are ultimately superior document, and therefore you will have to also adopt the treaty document as well. Now, country like India has a principle that it will be the treaty or the domestic law which is superior will be applicable to you. Now question arises, what will happen to those in the light of the GAR and all those BEPS and all those things is going to be a major challenge.
You also heard the tax morality panel right now.
Yes.
There was so much debate on fair share of tax, and I found some of the views interesting. Christian Kaiser in the end, the Siemens Global Tax said that yes, we are aggressive at times, but that is within the legal boundaries. And many a times we even sound off the tax authorities regarding the positions that we take. You had Mr. Philip Martin, the judge from the French tax code, who also said that tax morality, has to be connected to a judicial principle. It has to be connected to a judicial principle. Tax morality in itself cannot sway the courts.
That is correct. I think he was very clear as a judge on his point, even though he used a phrase, I think, saying even a shocking scheme can be correct if the law is clear. I mean, there is not a matter of right and wrong, but rather legal or illegal. And that is the discussion judges have to take. And all this morality, it's okay to give a background or a context, but not to make a decision.
The exact wordings of Mr. Martin: shocking tax scheme may work if the legal the text is clear.
See, the issue emerges out of the whole discussion is, although people are talking about that how taxpayer should do, but what the tax authority should should do. Nobody talks about that. And what the Christian said is that exactly you define the law clearly so that no issue arises. You should have APA. The country like India, you do not have APA for the domestic player, and now you are creating such ruckus problems which are going to create major problems.
And the one point that came up for discussion in that panel discussion was GAR and tax morality and GAR and taxpayer rights. And I think what stood out for me was one pointer in one of the slides by, I think again, Christian Kaiser, that mere reduction in tax or mere saving of tax should not lead to applicability of GAR.
I absolutely agree with him, because the GAR has all undefined terms, all complex terms which has no clear-cut meaning, no clear-cut meaning, absolutely subjective. And you want certainty, how do you expect people to behave?
That's the paradox.
Yes, and something that I think I can say is I have not yet found any legislation in any country in the world that says that you have to make the election, you have to choose the most expensive tax treatment for your transactions. There is no such thing. And as long as there is not an obligation to do that, it seems that the general context, the assumption is you should be able to plan your business, to make your decisions, and if in those decisions you are saving on taxes, okay, that should be it.
Before we say goodbye to all our viewers, I must make a mention that we are standing here at the IFA Mexico 2020 booth. So next year Seoul Congress, the year after London Congress, 2020 we are going to be in Manuel. Manuel is going to host us all.
I will see you there.
Absolutely.
No, but let me honestly tell you, the Mexico conference will be one of the most interesting conference, because that place is worth going.
We are going to play the Mexican wave.
Thank you.